William, hopefully your favorite videographer from Two Hats Publishing. I welcome you to another Two Hats special of community events. Let's look in and see what's really happening.
I hope everyone had a chance to have lunch, and I hope you enjoyed it. I thought it was very good lunch. So we thank the staff here at the Hall of State. Hope they send their greetings, and they hope that some of you will come back to visit. They have, I guess, the most visitors in this building during the State Fair of Texas. And what they were telling me is that mostly of the year, this is the home of the Dallas Historical Society. And if you live in the area where they have the exhibit, the Martin Luther King exhibit, behind that there's a library where researchers and writers come to do research. And so that's another very interesting part of the building that a lot of people don't know about, that they have a library here. So there are reasons to come back and visit. So we have our next panel ready, and this is going to be a very interesting panel. We have experts from both private industry and from HUD and from the City of Dallas to talk about critical issues related to fair housing. And these issues include things such as criminal background and disability. So at this time, I'm going to ask Barksdale Higgins, who is the Compliance Enforcement Manager, to come forward. Barksdale will be the moderator for this panel, and he will come and do the introduction and direct the panel further.
Thank you so much. I'd like to welcome everyone this afternoon and thank you for your attendance. Did everyone get a great lunch? This has been a fantastic event so far, and I hope you found it to be insightful as well. If you enjoyed this morning's session, you're going to certainly get a lot out of it and enjoy the session this afternoon as well. We have some real superstars on our panel who will be speaking to some of the more critical issues that we face in our office dealing with fair housing. Again, my name is Barksdale Higgins. I've worked with the City of Dallas Fair Housing Office and I answer to Ms. Beverly Davis. We investigate complaints of housing discrimination. So if anyone has an issue where they feel that they have been mistreated or perhaps discriminated in some manner in trying to seek or obtain or even maintain housing, they can come to our office, file a complaint, and then we will conduct an investigation to see whether or not whether they have had their rights violated or not. So what we want to do is look at some of the more, or at least two critical issues that we see on a regular basis, or certainly growing now, that has caused issues and consternation, certainly for housing providers, people in the business owners, as well as people who are managing properties, leasing agents, things of that nature. Tell me something, give me a show of hands first before I even get started into that. How many people do we have in the audience who are actually in the business? They either own properties or they work for a management company or they're leasing agents. Can you give me a show of hands? Oh, fantastic, great. And we certainly, we want to commend you, because a lot of times when you get that call from our office or you get that notice from us, we know that we sort of have this thing come over here, oh my goodness, what's going on? All of a sudden I'm under investigation. And we certainly understand where you come from. That's why we wanted to have this event and this session here for you today as well. A lot of times, we're under the impression that we are, or at least our office, or even HUD for that matter, are advocates that are out to get you. And that couldn't be further from the truth. We appreciate the service that you provide to the citizens of the city and to the area as well. You're a valuable resource in providing housing. So we wanted to provide you with information today that will help make your jobs better, to empower you so that you will know and be able to understand and recognize some of these issues so that you won't fall into certain traps or make mistakes along the way when these types of things occur. So before I get started here, I want to at least identify our panelists for the day. We again have some superstars here, both from the private industry as well as representatives from government entities who are responsible for enforcing and making sure that these laws are complied with. I'm not going to go into your bios of each of the panelists here today. You have that information in the program booklets that were provided to you earlier, but I do want to identify them first of all before we get into the discussion. What we're going to do, and let me just sort of back up and explain sort of the format. We're going to look at one issue first, probably the issues dealing with criminal background checks and how they may be used to qualify applicants or even tenants who are on a property. The second issue that we'll look at is certainly a hot issue, not only here in the Dallas Metroplex, but nationwide, are tenants or applicants who make requests for reasonable accommodations because of their disability. So we're going to look at that during the second hour. But back again to our panelists for today. To my right here, this lovely young lady sitting here in the peach-colored top here is Miss Kathy Carlton. She is the Director of Government Affairs for the Apartment Association of Greater Dallas. Next to her is Mr. Robert Blinn. He's an attorney at law at the Blinn Law Firm. We certainly depend on him in our office from time to time discussing different issues that may come up. To his right is Mr. Jerry Carlton. No relation to Miss Carlton, again, they just happen to have the same name. Mr. Carlton is an attorney with Glass, Phillips, and Murray PC Law Firm, and he represents many of the responding parties that we happen to interact with, and in some instances even investigate. But he has been a great person to work with, always amenable to trying to look at options available to resolve these types of complaints. Now, on the government side, and that's what we'll sort of identify the other table as, the government side, because they're on the enforcement side. They work with either the federal government or the local city government to maintain and make sure that the laws are complied with, and also to provide resources to you, the general public, if issues come up that you need advice or guidance on. First here at the table to my right is Mr. Thurman Miles. Mr. Miles has been with HUD, I know, long before I came to the city here and started working for the city of Dallas. He's the director of Region 6 FHO Center, representing again the U.S. Department of Housing and Urban Development. Next to him is Ms. Melissa Miles. She is the Executive Assistant City Attorney in the City of Dallas City Attorney's Office. And when we have complaints, Fair Housing Office, once we complete our investigations, what we do is we will send up a report with all of the data and evidence to Ms. Miles and her other attorney. I'm going to have Mr. Richards stand as well. He assists Ms. Miles in reviewing our cases and actually making determinations on the case. And boy, they are a valuable resource. I don't know what we would do without either one of them. Thank you again, Ms. Miles, for your participation. She's with the City of Dallas. Last but not least is Mr. Patrick Vanis. He's the branch chief for Intake Division with FHEO Region 6 for the U.S. Department of Housing and Urban Development. And I've seen, Patrick, he was an investigator at one time, and I've just seen him sort of matriculate through the government system. And I call on him all the time as well. So Patrick, he says, all right, I know who it is. I see you on the bed line. And he'll pick up the phone and he says, okay, what do you want and what do you need? So, I'm always thankful that I can contact him at a moment's notice. So what I want to do is get right into the issues here so that we don't take up too much time so that we can address some of the issues that are certainly important to you. So first of all, what we want to do is look at some of the issues pertinent to residents or even applicants that come in when you're qualifying them regarding criminal background and criminal history related to these individuals. So I'm not sure whether Mr. Carlton or Mr. Blinn or Ms. Carlton would like to address that first, or share your experiences with the clients that you deal with.
Yes, I'll be happy to do that.
I'm sorry.
you. I am Jerry, but not Jerry Springer, so I'm not going to be throwing tables and chairs around there. Just a few comments to begin with, and then I actually have some questions that I'm sure all of you have, or many of you have, for our HUD and City of Dallas representatives when it comes to dealing with claims that might be made, and the uncertainty that exists right now on what policies and practices that might be deemed acceptable under criminal background or criminal screening issues. First thing I want to point out to everybody is most of the issues relate to the disparate impact type of claim. And that essentially does not require that you have any intent to discriminate against a particular person. It means that because of the disproportionate percentage of racial minorities that are incarcerated or convicted compared to the general population, that it's more likely that if you have a blanket criminal conviction policy that prohibits any occupancy or any acceptance, that you're going to be discriminating against an African American or Hispanic just based on the statistics of that national level. So it doesn't even mean that you're intending to discriminate against someone based on their race or national origin. And forget that. It doesn't matter what you intend to do. The second thing is that it's important that you be educated about how to deal with the process. And from my experiences so far, and from what I hear from talking to other attorneys and people in the management business, one thing I don't see happening as much as I think should be is that the suggestion in the guidance from the HUD General Counsel's Office that you delay your criminal screening process until you have conducted all of your other screening processes will reduce the number of times you have to deal with the question of whether or not you need to make some kind of evaluation relating to a conviction. So that would be something that I recommend you do, is delay your criminal screening until after you have finished the rest of the qualifying process. In other words, their credit check, when you check with other landlords in the past, all those kinds of job, income, etc. Do all of that first. And then if they pass, then you do the criminal screening. Then, when you do apply the criminal screening criteria, I suggest you make very detailed documentation. And I put that in parentheses. That's if you're doing a good job and doing it in accordance with the way the HUD guidance suggests that you do it. Because at some point, when someone did make a claim against you somewhere along the way, it would be helpful if you were able to maintain some statistical information that showed in the past that you had approved a person of the same race with a similar crime or something like that 3 times or something along those lines, so that it would be evident that if you are applying your policies and practices in an appropriate way. I would suggest you keep those records separate and that you keep those like a statistical analysis of all of your acceptances and all your denials relating to criminal convictions. Now, the HUD guidance, everyone should read this many times. It's published April 4th of 2016. You can get it at the HUD.gov website. And it's very extensive. About 95% of it relates to this qualifying and the disparate impact kind of issue. So learn from that. There's also another publication out now that's just published by the Austin Travis County Reentry Roundtable, and that's at reentryroundtable.net. And that was a project that's been ongoing for a year or two in the Austin area that has been now resulting in this paper being published, as well as a template for a criminal screening process, and it's based on this study and this work group. And I think it's very helpful. I'm not saying that you necessarily need to apply the exact look-back criteria they're suggesting, but it would be helpful if you review that information. I think it's a good guide for you. Now, let's go with some of my concerns and questions that I have for our panelists that might be enforcing. Kathy has a couple comments.
Thank you. Because I know once we get into questions, it'll probably be pretty intense. I've worked for the Apartment Association for just about 25 years now. And so over the course of my career, I've been invited to attend a lot of re-entry kind of conferences like this, folks that work with folks that have been incarcerated for one thing or another. And at the same time, we have cities breathing down our necks saying, we want you to get rid of all the criminals, we want you to be really tight on your regulations. We have one city, very large city in the Metroplex, that if you're considering anybody with any kind of criminal record, you have to run it through their police department as well. I fight that all the time because I don't believe that they have a right to invade a management company on what their rental guidelines are. But we have cities like that are very concerned about the criminal element in their city. So we have the pushback from that side. Then, as I said, we've got pushback from other groups who are trying to help people with a criminal background. So I personally am very glad to see this. Now, I would say that, 5 years ago, I never heard of the term disparate impact. In fact, I've had to correct many people who think it was desperate impact, and we learned that that's not what it is exactly. But, so I was glad that HUD stepped in and made a ruling about it. And Jerry's right, you need to read it at least 3 times. But I will say, even after you read it 3 times, it gives a lot of ideas about what you should do, but it doesn't tell you exactly how to. And so with all these fair housing cases, and we run up against this all the time, there aren't clear guidelines. So you're kind of fumbling around, trying to come up with a policy, and then you find out the only way it's going to really be decided in, yes or no, black or white, is when somebody goes to court over it, and some judge rules whether or not that's gone too far or not far enough. So in the area of disparate impact, I will tell you that when this ruling came out in 2016, it did send shockwaves through our industry. And so many of our large management companies, at least, got right on board, called their attorneys like Jerry Carlton and said, okay, we've got to look at our screening policies. And again, I think this was a very needed exercise because we had many companies that just, their policy, blanket policy, is if you have any kind of a felony record, we have a 99-year period where we won't even look at you. And there were cases that I would hear about that were really quite unfair. So again, as a property management company, you have to balance between, do I want to let somebody in that's got a known history of violence or criminal activity and jeopardize the health and safety of my residents, or do I give this guy a second chance who stole a car when he was 18 and he's 56 years old now? And those are the examples that we were getting. So again, I'm very glad to see that this has come forward. But my complaint with HUD is always that they haven't given us enough guidelines, so we're out there floundering with attorneys trying to figure out how far to go. But I will say most of the major management companies have reevaluated their criminal screening. They still don't have to accept felons, but at least they're looking at the length of time since a crime was committed, and they're looking at the nature of crime, drug manufacture, and sexual deviants are still those 2 categories where everybody is no. So good luck finding housing for those folks. But in general, it's been a very good exercise, and it's moving the pendulum, I think, a little bit more towards the center where it's needed to be.
If you can, we'll allow someone from HUD now to sort of address that.
Yes. Okay. I want to go back and give a little bit of historical perspective on the issue, since I think we at HUD are the ones who kind of started it. We had a situation where in housing that's funded through HUD funds, we had something that was called one strike and you're out. I mean, historically, if you had a criminal record, you just can't get housed. And so if you look at public housing and affordable housing, we've been talking about that all morning, where they receive federal funds. If people who are coming out of prison and have been out for 20 years cannot be housed there, that was a problem. And so, and the other one was that even if you had an arrest record, you couldn't be housed in many instances. And I think that the government looked at the number of people coming out of prison every year in America. If you add them up, they're in the millions. So they decided we need to do something. Now, the one strike you're out was our policy too. But we changed that. That's the first thing we did, is we gave directive to our Public and Indian Housing Department to relook at their one strike you're out policy. And basically it said you don't have to, I mean, we were hard about that because we had situations where there were so many criminals in public housing that other people couldn't live. I mean, I went out on an investigation and I go to interview a tenant and we hear pop, pop, pop around the corner. I mean, all this stuff going on, it was bad. And so after years of that policy, it was relaxed. And, you know, just having an arrest record would not disqualify you from public housing. It had to be a conviction. So that's kind of where we started. And then when we started looking at, okay, those who've been convicted, how long does it have to be before, you know, they've served their time, done whatever society said they needed to do, before they can come back and apply? And we had some really, really extreme instances where people have been out for 15, 20 years, and they still, you know, would automatically be denied at certain apartments. Others might be more lenient. And so that's kind of where the background came from. And so then the guidance came out that was referred to earlier, that our Office of Counsel came out with, and that's one of the things it said. Now, having a criminal background, that is not a protected basis for a fair housing complaint, for example. So someone cannot file based on having a criminal record. But if they are aware of someone who is treated differently, of a different race or background, then they can file a complaint under the Fair Housing Act based on differential treatment. That's one thing. But the other way that was also mentioned is the disparate impact. And disparate impact, of course, policy is neutral, but it has a disparate impact on a particular group. So that's where the guidance came from, and it started the conversation. It's not one of those where I think we have the answers, but it reminds me a little bit of reasonable accommodation, which we're going to talk about in a little bit. We wanted to encourage landlords and owners to at least look at each applicant on a case-by-case basis and evaluate their own policy in terms of their reason for having the policy. Most stated reasons were to protect the health and safety of other people who would be living at the development or at the complex. And so the whole disparate impact goes back and forth in terms of having a legitimate defense based on health and safety, or as a pretext somehow for even unintentional discrimination. Does it have an impact? And so I don't have all the answers, but I wanted to give you that little bit of background as an introduction as we continue to talk about the topic, because that's kind of where we are. And I see both sides. I'm a landlord too, so I see both sides. But if I know one thing, you'll have revolving doors. If people can't find a job because they have a criminal record, and if they can't get a housing because they have a criminal record, you don't give them much choice but to do something else. They have 3 squares and a roof over their head in prison, and that's the way a lot of people look at it. But I'll just stop it there and let if anybody else wants to say something.
Did you have any additional comments that you wanted to?
Yeah, if we could just talk about the disparate impact. There's a 3-step process that the guidance talks about. The first one talks about that basically the complainant would have the burden to prove that they that the practice has a discriminatory effect. And the guidance really refers basically to statistical information to determine that. So if someone makes a complaint, is it going to be a burden for a complainant to provide you with statistical information that there is the discriminatory effect based on them being in a particular class? Or are you going to, should we just expect as management that it's kind of presumed that they're in that class based on the national statistics that are referenced in the guide or some other statistics.
In terms of the burden on the complainant, we don't normally force the complainant to provide the data to support the impact. HUD, if we're talking about an individual, HUD will usually, or the BAP, like Dallas, would do a sample, usually a targeted sample of the area or even the community that we're talking about to see what the demographics look like at that property. So, I mean, in terms of on the front end, we know that the statistics support the disproportionate representation in the prison system. So we've already got that one part kind of locked in. So then it becomes more individualized in terms of when you go out to the property, can we show that this policy, well, one, what is the purpose behind the policy, and then two, what impact does it have, and can we point to a particular group of people being overburdened and turned away? And then you could, and just wearing the investigative hat that I wore for years, one of the things that I would be looking at would be not just who they've turned away based on that policy and what is the racial makeup of those individuals, but I'd also be looking at the makeup of the properties to show that there is some relationship between the two.
One thing that you said a few minutes ago that I've gotten used to it now. I've gotten used to hearing it from HUD, and it doesn't send shivers down my spine anymore. But for many, many years, we teach fair housing classes at the association all the time. Every few months we're doing a fair housing class of one kind or another, especially with whatever is the latest thing to be tested on. But for years, our members have been told, or we've told our members, establish a policy, whatever that is, and then close your eyes. It's applied the exact same way across the board, no matter what the person looks like. And so we've all gotten into that road of doing it that way, and now HUD comes out and says, well, we'd like you to evaluate each case individually. And that scares the socks off me because, you know, a lot of these decisions filter down to the property level, and you've got big management companies, maybe with a policy, but then if you allow an individual manager, maybe one might be really tender and soft-hearted and let a bunch of folks into, oh, I think you'll do better here, and then the next thing you know, you've got some problems. Or they're too strict and don't give folks a second chance. And so, again, that scares me when HUD wants us to look at each individual case because, you know, everybody thinks they can read character. And I hate to admit it, but a lot of times you can't. You know, sometimes folks are really good at hiding who they really are. So you might think, oh, this is a great person and we're going to let them in, and then 3 months later you're thinking, what in the world did I do? So it, again, scares me a little when you say evaluate each person individually. I'm much more comfortable with a set of guidelines, applying them. Again, I'm not looking at the person, I don't need to know what they look like. I just want to apply them across the board.
You can weigh in at any time. You don't put a mic in front of me, it's a dangerous thing. I get that, but to dovetail on what Jerry touched on with his initial comments, I think that, you know, the reentry roundtable is a good starting point because they worked in concert with various stakeholders to try and you know, cobble together what they thought would be a reasonable approach to how you look at and evaluate these cases that pop up. You know, when you do have somebody that you're going to have to turn down because of a criminal history, or, you know, evaluating whether or not to house them based on that criminal history. And so the roundtable has provided a considerable amount of research and also recommendations on what they, you know, in their communications with the Austin Apartment Association and some of the other groups down there as to what they think those look-back periods should be. Now, those were premised off of, in part, what HUD holds up as a best practices agency, and that's the Housing Authority for New Orleans, is for a couple of years now had a process for applicants who get touched in that, criminal history conundrum. And so they have a review process and a hearing, and they've provided some feedback on, look at how engaged they are in the community, how long ago was the offense, was there a pattern, and then make some decision. And so while it's not the bright line that we would all prefer, it does kind of get us out of the tender-hearted or the heavy-fisted problem that we do encounter at a property.
I just wanted to add to that, Patrick's right on the head, is the policies. I think what came out of HUD's policy is a recommendation that we relook at policies and maybe do some revisions, because you have the two extremes. You have those that had policies that said, if you have nobody that has a criminal record gets in. Well, that's fair because it's applied to everybody, right? Well, I think what this brings up is that there's a group of people out there, that there are some folks in that group that perhaps would be good tenants. And now it's a question of how do we screen? We're still going to have a policy. When I said case-by-case basis, I didn't mean to imply that each applicant comes in. No, you still need a policy, but try to revise that policy in a way that makes business sense, as well as good sense in terms of what we're trying to do. And as we usually do at HUD, we don't tell you how to do it, which is why we're having the discussion now. But that's what we're trying to encourage, though, is revising the policies in some way that makes business sense for that landlord, but at the same time gives individuals who have demonstrated that, they're back in society, they're trying to live and work and take care of their families, and they need somewhere to live, and we need a process for doing that. So I just wanted to add that to Patrick's comment.
So speaking of policies, I think that's the biggest question in everybody's mind at this point. First are the policies. So what seems to be out there very often now is a policy that people are establishing look-back periods with regard to segments of crimes or types of crimes, and they vary that depending on what the crime is, etc. But there's a wide range of policies out there right now. I've seen 15 years for certain felonies. I've seen no period is acceptable for violent crimes. If you're on the sex offender registry list, you're not getting in here. Those kinds of policies on that one extreme. And then on the other extreme, I see that, like the Reentry Roundtable paper suggests that when it comes to somebody on the sex offender list, that every one of these should be looked at individually, because there's such a wide range of types of crimes that put you on that list, that it could be something as simple as a college kid that was urinating by the side of the road and they got on the list for that kind of crime versus more serious crimes like rape, etc. So, but if you have a sex offender registry list prohibition completely, then I think you're at risk of a claim when someone's hasn't done anything beyond that, if they're given the opportunity to explain the circumstances of their particular conviction. And it seems to me that the HUD guidance and the Roundtable Reentry both suggest that if even for crimes within the look-back period, let's say you say let me think of a crime, a felony crime that involves violence for 4 years, and someone had a conviction that was only 3 years ago, you would say, well, it was less than 4 years ago, so we're excluding you. I don't think that's what the HUD guidance is saying is enough. They're saying, well, in that circumstance, then you should look at that individual circumstance and see what the situation was for that crime. And that might be, they were defending their child or something like that. Or The risk of that for you is that someone makes something up and lies about it, and then how do you examine that, how do you deal with that? And I think that's the stuff that Kathy is expressing the industry's really afraid of, is when they start doing individual assessments, that they're going to get in troubles unintentionally because of the differences in how people examine things or who they trust or things like that. And that's why a fixed look-back period is a lot more comfortable for people, because then they know, well, if you did it within 4 years, if your conviction is within 4 years, you're on my list, and I know I can safely say that we're rejecting you, and our policy to do that is because we're trying to protect people and we're trying to protect property, which are justifiable reasons. I guess the questions are, do you see a risk there for someone who has the more extreme policies that I was describing to you?
Well, we're always going to have disparity impact. Someone able to file a complaint based on that. But the extreme of having no look-back policy at all to the type of policy you're talking about, where you determine that, okay, we think at this property, the look-back period should be 4 years. That's the example that was used. Well, if that's your policy, I mean, you're comfortable with it, I would say go with that. Because we at HUD, all we're going to do is someone files a complaint, we're going to take the complaint, we're going to investigate it, and I think, as Kathy had said earlier, it's going to take some court action, some court cases before we really start to see how this is going to work out. We're at the stage now, as we were back with occupancy standards years ago with familiar status. We couldn't tell you how many per bedroom was reasonable under the occupancy standard. Y'all laughing, y'all remember that. And I think that's how we're evolving in this policy as well. But it's certainly better to have a 4-year, 5-year look-back period, and at least you'll consider people who are beyond that from one that had none whatsoever. And so I think that's what HUD's intent was to start this conversation. I can't speak fully for HUD, but that's my thinking, having worked there for 30 years, to get the discussion going in the housing industry. And I really do trust us to be able to figure this out. In addition, I believe sex offenders and folks involved in illegal manufactured drugs, that's the two categories that the policy said you don't have to make any exceptions for those two. But your point is well taken. There may be somebody in that group, who would be found worthy to rent to as well.
I would like to, and these are all incredible points. My perspective of this is from the homeowners association side of things. Some call them property owners associations, POAs or HOAs. And we're not really having to deal with the criminal background stuff on a daily basis, probably because of more avoidance than proactiveness. When I get clients that come to me and say, hey, we're really wanting to do a criminal background policy, my first inclination is to try and steer them away from it as quickly as possible because of some of the pitfalls that they might experience. They're not dealing with this on a day-to-day basis, all the ins and outs of it. But one of the things that I always bring up is a point, Thurman, which you were making, which is I try and direct my clients to when I say, well, what types of criminal element do you want to exclude from your neighborhood? And most of them, being untrained volunteer board members, they don't really know. They're basically all felons. I say, okay, well, great. Well, what type of felons? Is there a difference between somebody that may have been convicted of securities fraud, Martha Stewart securities fraud, vis-a-vis a rapist? Absolutely there is. Should we exclude the rapist? Well, yeah. I think we would all say that that's not a no-brainer. But from the person that committed securities fraud, they're equally a felon, but are they precluded from really living in our neighborhood? So looking at the individual circumstances, at least from a property owners association, kind of makes sense on a limited basis. But it opens up so many potential pitfalls for them to make a mistake. It's almost like I try and say, if you're in a very heavy crime-laden area, then let's talk about it. But if you're just wanting to exclude felons because that makes politically correct neighborhood. You know, we're excluding felons, and maybe that's not the best thing for you to consider as a community. So I'm just throwing it out there. Well, I don't know what your experience would be.
I don't know. I think we had the first complaint filed in the country after the policy in Region 6. And it was a housing authority in East Texas. I won't name the name of them. But it was going to have to be disparate impact. But the case did settle. We didn't go all the way through. And they developed a really, really good screening. They already had a screening criteria. And all they really did was just revised it and to something they were comfortable with. How were they going to get the local statistics on criminal activity and that sort of thing? And it worked out real well. We've not had a lot of complaints filed yet. So I think it's working, you know, just as you guys are struggling with it, your clients are struggling with it. I think it's working because I've had one or two in Oklahoma. All of them ended up being settled because when people start looking at the policies that they had in place and then thinking about it, oh yeah, we could change this or we could change that, and it worked out in those cases. So we haven't had one yet that went all the way through investigation, you know, to get charged and go up as a court case. There may have been some in other regions, but we haven't had one from our region. But I think that all the things that you're saying make sense. It's just that, the public housing authorities, that's what they had to do. They had to look at their policies, and then remember, they were one strike, you're out. All of their policies were that way. That's it. You have a criminal. They even had arrested. You've been arrested. You get arrested on the property, you're evicted. Those were the policies that were in place before we came out. And I'm talking about the HUD's Public Housing Authority agencies. And so I see us moving in a direction to, and then you mentioned something about keeping statistics and documentation. I think it's important for housing providers as they start revising their policies, and you know, they have this fear in the back of their mind about what's going to happen if I rent to this person. Keep stats on what happens with people that you rent to, so that as you go, you can say, well, we tried that, and here's what happened. And that's why we have the policy we have now. So I think as we go forward and we revise our policies and look at things that we think are important, because the real key is, if it's a tenant that will come in and pay their rent and take care of the property, I think you want to have it. And I have to believe there are some people out there with criminal records who are like that. I've had people call the office. I've been an investigator. I came up through the agency the same way Patrick did. I started as an investigator, called me and said, hey, I want to rent this. I've been out for over 5 years now, been on the same job. My wife left me. I'm raising my 3 daughters. I want to get a house. I want to go to a better area than I'm in, and they won't rent to me. And back then I said, sorry, we can't take your complaint because it's not a protected basis. And he said, well, I thought this was fair housing. I said, it is fair housing. He said, well, this, by God, is not fair. So, you know, and all of us probably had to turn down people, you know, coming that way. So I think it's a step in the right direction, but it's a tough issue. It's a really tough issue. And I don't know if Patrick wants to say anything on it, Melissa does, but that's kind of where we are. We've had a handful of complaints, but I think the policy change itself is having a great impact.
My turn. Well, the truth is, I just wanted to say, echoing what Thurman said, we haven't received just a lot of those kinds of complaints. We've had some that have gotten a little bit on the fringe, and I'll give you an example, where we had a complaint that a tenant, she was an able-bodied tenant, had received a notice of violation in her lease for having an unauthorized occupant, but the unauthorized occupant was her fiance, who was spending a lot of time there but had not completely he moved in. So they said, get him on the lease or get him out of there. So they got married, and then she went to put him on the lease, and then they rejected him because of his criminal history. And a little bit more of a twist to see the conundrum is I believe their policy was they excluded all felonies. When they looked at this particular person's record, he had been incarcerated as a young adult for a relatively minor crime, and then was subsequently convicted of murdering someone who was in prison with him. So it's very, very complicated analysis of that case, but you can see from the beginning how problematic it is to tell someone that their spouse can't live with them. So you're dislocating someone who doesn't even have criminal history because of someone else's very old criminal history.
That was an HOA too.
Yeah, I think that was in a condo complex. That's right. So, and I'll make one other point, and that is, because we've had a fairly recent federal case on this issue, but that's where criminal history also sort of meets disability or request for accommodation. We haven't seen one of these cases in Dallas, but I'm sure it's going to come up, is where where the event that resulted in their conviction with a crime, their credible claim is that the crime took place in, for example, a psychotic break for someone with mental illness who's now being treated, is in a stable place in life. But the criminal history itself is related to their disability. And so in a request for accommodation, they asked for an accommodation from the criminal background policy of the housing provider. So there was a recent case on that, and it came out, the court found in favor of the complainant and said that the accommodation was reasonable and it was related to the disability. So there's another twist on background checks.
Thoughts swimming through my head.
Steal that case?
No, actually made me think of something else, and then I'm always tempted to go off topic with something else. So, no, I guess in terms of intake, the practice was for years. Criminal history was not a protected group, and then the guidance came out, and I kind of had to put an old hat on that I hadn't worn in a long time, and that was my undergrad was public justice, which is kind of an offshoot of the criminal justice degree program, and started thinking about recidivism and rehabilitation, and ultimately I think the point is we're trying to end a cycle that people get caught in, and if we can do that, then we probably have some obligation to try and facilitate that. And so while I agree completely with the panelists, that A, HUD's not going to tell you exactly how to do it, and B, it creates a difficult business model in some sense too, because there's not a right line. I do think we should keep in mind that we are talking about people that need a break. Some of them, not everybody's a good guy, so I have no illusions about that. So, but there's plenty of people that are trying to do the right thing and trying to do better. And those are the people that we should be focused on.
Can I say one other thing?
Yes, ma'am.
Barksdale?
Yes.
And nobody said it, I hear it sort of being alluded to, and I'm not speaking, not expressing any sort of opinion of the city of Dallas. I don't know if any of the policymakers would agree or disagree with me on this. But I think it's important sort of to point out that the reason I believe it's at the heart of the disparate impact that policies, that criminal background policies have, is because like in my generation, I guess I'm kind of, sometimes I'm called a baby boomer and sometimes a Generation X, but I know that I've lived through, we've had decades of mass incarceration of minority youth. Those folks are now my age and older. And I think sort of the elephant in the room is, I mean, that's what creates this incredible disparate impact today, is these decades-long policies that now have people who have criminal records that perhaps should not disclose, perhaps would not bear out that they are a safety, have their safety risk to the communities, and yet are running into policies that they just can't, they're relegated to the worst housing choices possible, which becomes sometimes no choice at all.
Thank you for that. I don't want to cut this short. As you can see, this is a complicated issue, but there may be a couple of questions before we move on to the next topic. So I wanted to at least give some of you in the audience, at least, if we have 2 questions, we can entertain them before we move on. Do we have any questions? The gentleman here, I'm sure.
So can you elaborate a little bit? I've heard a couple of times people talked about keeping a separate list or a documentation of the decisions that come back versus what the outcome actually ends up becoming. Can you talk about how doing it? In my mind, and maybe I'm thinking about this wrong, but to understand the impact, the disparate impact, and the crime portion of it, you would have to document the crime and race in order, and outcome, those 3 things, in order to understand what the impact actually looks like. So how do you do that and avoid any type of perception of denying somebody based on it?
Well, I'll say it again. I would think that you would do it as part of your screening process. The policies that I've seen revise their policies to try to, be able to take a look at people with applicants who have criminal backgrounds, is you get a report through, and I don't know enough about how it works to tell you what agencies provide these reports, but on those applicants, they will provide you with a report of what they did, how long they've been out, and all that stuff comes in as part of the review process when you're doing the screening. And that's going to be a part of their file. If they have a 1-year lease and they stay 6 years, after you rent it to them, you're going to have that record. If you decide not to rent to them, then there's going to be an applicant file. But I'm just saying, you usually have files anyway, and that would just be one additional piece that would be in there. There are local crime statistics that through the police department, and the state has, those statistics, and some people use those in their screening, criteria, and you just go from there.
We'll take one more question.
If you were illegally evicted and you know that you won the case, can a landlord still hold that against you, and how do you get that off your record?
I'm sorry, did you say that, when you say we're illegally evicted, was the tenant won the case?
Yes.
So if the tenant won the case, then they would not have been evicted, so I'm not sure what you're asking.
I'm sorry, you were illegally evicted and it's still on your record.
You were legally, you weren't evicted legally.
Illegally.
Illegal. I'm not understanding that.
If it's
like locked out and not gone through court and gotten a judgment?
Right.
Then if it's not a judgment, how is it on your record? Just the landlord reported it as an eviction?
Yes.
Okay.
Landlord reported it as an eviction. It went against your record, but it was something you know that you did not do. But some landlords have a way of putting it on you.
Right, they can report on credit reports, et cetera, services that do that kind of information. And I really am not sure how you would do that other than dispute the credit report. And there's a process that's online with those credit reporting services that describe how you dispute it, or get some legal assistance that specializes in that kind of work.
I know we're wrapping up. I have one thing I want to say. So the Apartment Association of Greater Dallas is our local affiliate. We're part of the State Association, Texas Apartment Association, otherwise known as TAA. And as soon as this guidance came out, they met with the board of directors, and I'm happy to hear that really we haven't had a lot of cases come forward. And I think part of it is because we jumped on it pretty quickly. And I just want to read to you something that they sent out. They have an application, a TAA application, and I will say probably about 90 to 95% of all apartment and rental properties in the county are members of the association, and they're a member pretty much so they can use that form. But what they did is they took out certain wording that had always been in the application, and so it says, has your spouse or any occupant ever, and then what they took out is been charged, detained, or arrested. And then that was resolved by conviction, probation, deferred adjudication, court-ordered community supervision, or pre-trial diversion, and then been charged, detained, or arrested for a felony or sex crime that has not been resolved by any method. So I think just by taking out those couple of phrases and sentences, it really circumvented a lot of the issues maybe would come forward. So they did that proactively, and I'm hoping that's what led to a minimal number of cases.
Thank you. Well, we want to sort of shift our attention now to an issue that has certainly caught fire, not only in the Dallas Metroplex, but certainly, I believe, across the country. In our office, we see a lot of complaints that are filed with us by people with disabilities who believe that they have been in some way been mistreated or discriminated against because they have made a request for a reasonable accommodation. Those of you in the audience, how many of you, show of hands, understand and know what a reasonable request for a reasonable accommodation is? Raise your hand. Raise them up. Okay, so we got an educated crowd here today, so we got a good group. So we don't have to really go into a detailed explanation of what that means and what is required. So what I would like for the panel to do now is to discuss some of the issues that they see take place or that certain properties have experienced in dealing with their disabled tenants, or perhaps an applicant who is disabled who is making a request for a reasonable accommodation. And this would apply to not only multifamily housing situations, but also those who are in homeowners associations or neighborhood associations that are dealing with similar type issues. So what I'm going to do is turn it over now to Mr. Green.
Thank you, Barksdale, and we really appreciate the opportunity to be here today and share minds that are smarter than mine. I tell you what, there's lots of good information here, and hopefully everybody's absorbing it all. I'm going to be coming to you today from the standpoint of homeowners associations or property owners associations. Jerry and Kathy can also speak to this issue from their experience dealing with the apartment side of things. Probably not too dissimilar in terms of the issues that confront them. But from a day-to-day standpoint, my practice predominantly rests with dealing with homeowners associations. Before I kind of get into the specifics, what I really think is important is, while probably everybody in here understands or has a concept in their minds of what a homeowners association is, perhaps I ought to give a little bit more context to really the enormity of that type of living experience, okay? In the United States right now, or at least as of a few years ago, there was over 333,000 planned communities. That's affecting about 26 million housing units and about 66 million residents. So about 1 in 5 of us in this room and throughout the country are living in some type of planned community. In Texas, There are about 19,000 planned communities with 3 some million residents. So the topic of the reasonable accommodation, and for the purpose of today, we're mostly talking about ESAs or emotional support animals. That topic is a very real topic that is not only generating a lot of interest here in the Metroplex, but throughout the country. These property owners associations can deal from anywhere from 4-unit condominium complexes to high-rise condominiums, to master plan communities, to a single-family lot development of 20 homes. So it is, every time you drive down the street, you can look left or right, and you're going to come across one of these communities. Just like if you were driving down the street, you might see an apartment complex. So the issue of accommodations is very real and alive within the communities that we represent. Now, a little bit different from the apartment complexes is that almost all of these property owners associations are run by a board of directors that is elected from the homeowners, because they are homeowners. And they are unpaid, generally untrained volunteers. They go to work every day like most of us in here. They take their kids to school, they go to soccer practice. They struggle with making sure they have enough time to pay the bills, etc., and maybe they watch their favorite show. And then they've got to go deal with the HOA finances, the complaints from homeowners, dealing with a second job, basically, in running this community. Yeah, they volunteer, of course, and they have to remind themselves of that. Some of these communities are managed by professional property management, and some of them are not. So those that maybe have professional property management, we would hope, are getting a little bit better information from their property managers on these issues like accommodations or background checks or whatever, than perhaps the mom and pop down the street that's running a 20-unit condominium complex and really can't afford a property manager. Right? So that's kind of a little bit of the background. From a practical standpoint, my job in representing these communities, it's not to be their general counsel, like on a retainer basis. So I don't have any one specific client that just pays me X amount of dollars per month and says, your job is to keep us up to speed on any issue that comes up regarding us at all. So, because they don't have the money, they can't afford it. So they're really going to call me, and it's usually when I get the call, it's after the fact. Okay? We all see that, right? And so it's after the fact. Mr. Hagan's office is calling me saying, hey, what's going on here? Or we're getting a letter, and we don't even have any idea that a request for an accommodation has been made. Not that we don't try and tell these communities that when they are confronted with these situations to please call us first. It's just that they're so busy, and their perspective is this. When you're dealing with a homeowners association, they have a set of deed restrictions. Those are things that are filed in the real property records, the do's and don'ts. There's also a set of bylaws. Most of them have a set of rules and regulations, and that's kind of really where, in the restrictions and in the rules and regulations, that we come and we say, oh, wow, there's these little things, like, for example, called pet regulations or pet rules. And, you know, they can vary from community to community. In a single-family lot development, you might just have dangerous, and a prohibition on dangerous animals loosely defined. Or there might be a breed-specific restriction, no pit bulls or something like that. Whereas in a small condominium development that maybe the units are 800 square feet, there might be a weight limit on the size, you know, or size of the animal restriction as well in there, because, you know, Great Danes are 100 and some pounds, whereas little poodles might be, you know, 20 or 30. And it might make more sense, given the size of the community, the amount of common area space, etc., to have some restrictions. Now, individually, without an ESA request, these restrictions might very well be reasonable. But that's when the ESA request comes in. We have to look at our rules and regulations and restrictions and say, given the circumstances now, are these reasonable and can we enforce them? My problem is that my boards generally will look at their rules and regulations and say, no pit bulls. You want a pit bull as a support animal? Sorry, it's a dangerous animal. Pit bulls aren't allowed in our community. You're denied. Next thing we know, we're getting the letter from Fair Housing saying that the complaint has been filed, and let's take a look at this. I try and steer my clients when I get to that position away from their decision-making process very quickly and to sit down and to understand what they've done. Maybe it was unintentional. Most of these denials are probably unintentional, but as we've heard, you can have no intent and still be in violation of the law. Ignorance to the law is no excuse. We know that. But from the perspective, and I keep harping on the HOA perspective, understand that they're you. You have the training here, but they don't. Most of these folks are just looking at their rules and regulations going, that dog's not allowed. They're not thinking beyond that. Okay? So it's awareness, number one. It's education, number one. And number two, what can they easily look at, absent calling an attorney and spending money, for guidance? We already talked earlier about, with respect to the criminal background checks, and I think it was Kathy that mentioned something about there's not clear guidelines sometimes. Or maybe it was Jerry. And I see that with respect to the ESAs. I mean, we could certainly look at the DOJ and the Fair Housing Office guidelines on these things, and, does this person have a disability, whether that's readily apparent or not, and, does the animal suit the needs or serve the needs of that disability? I'm not sure that many of those board members are qualified to make that decision. So a lot of times, and almost all the times, the answer is yes. You've got to just allow the animal because you don't know. You're not in a position to know, and you're not in a position to question that, absent some more perhaps clearer guidelines on what to do. So step back. We get a request for an ESA. This request might be a person that is filling out an application to be a renter in the homeowners association. All right, well, we allow leases in the homeowners associations, that's fine. She fills it out, doesn't fill out any of the information on an animal. No animals, no pets. She moves in. Next week, she's got a dog. Okay? Association says, hey, by the way, that dog is 60 pounds, and we have a 40-pound weight limit in this neighborhood. And the person comes right back and says, oh, well, that's an emotional support animal. And here's my certification that I got from the online certification place. And so we know that lots of states are dealing with this throughout the country on the online. As a matter of fact, I think I saw an article with some statistics, in case some of you don't know. There's about a handful, maybe a dozen or so online places that actually, if you pay them a fee, will certify your animal as a support animal, assistance animal. In fact, in 2011, there were about just one agency alone had about 2,400 animals registered. Today, or in this area today, it's about 182,000. So people are paying to be able to take this verification, so to speak, which requires nothing. It just you fill it out online, to be able to take to these homeowners associations who really know nothing about this topic and say, by the way, you can't deny me. And so I know that the North and South Dakota, Virginia, there's lots of states that have legislation out there that prohibits the misuse of or the misrepresentation of your need for a support animal in an application process. And, there might be some statutory fines or whatever. But I'm not sure that really helps in any of these associations that I deal with, or maybe even in the apartment situation. It helps them really identify whether or not this person has met the qualifications to have an emotional support animal. So I want to kind of just throw it out there. That's where I'm at from my homeowners association standpoint, and I don't know if it's much different or not from the apartment standpoint, but it is a struggle for these communities, and at the end of the day, I usually wind up saying, unless you want a lawsuit or a fair housing complaint against you, unless you have some absolute proof to the contrary, the answer is yes, even if you're in an elderly community that these pit bulls scare the heck out of these folks.
For the last several years, this has been the topic that we have dealt with the absolute most when we get calls in from our members. And it's taken a while to get a handle on it, but now we think we do. And to understand it, you have to go back and realize there are two agencies that govern the use of support animals. One is under ADA and regulations of that sort, and then there's HUD and the Fair Housing. So ADA, to me, at least has a reasonable definition, and I would recommend HUD go back and maybe look at it, because they recognize that a service animal is something that's trained, and they have in the definition that it's a canine, and then they have a little caveat there, and also some miniature horses can be in the category. And that applies to any common areas, so it doesn't apply to housing in particular, like rental or housing. So that's where you fall under fair housing guidelines. But ADA recognizes what a service animal is, and so we have to comply with it in our common areas. Although interestingly, we don't have to accommodate the guests, and they're certainly, because there's visitors and we have no obligation to them. But also, under the HUD guidelines, there's two types of assistance animals, and the first one is what we all recognize as service animals, and that's where there's an obvious need, such as the person is blind or deaf, or in some cases has diabetes, and their service animal obviously is performing a service for them that you can recognize. Then, of course, there's this new breed of emotional support animals, and that's where everyone's been going crazy with it. So, yes, as he mentioned, I went online today, and anywhere from $29 to, super duper $129, by answering 3 questions online, I can get the deluxe kit. It includes a little jacket, a certificate, and whatnot. We had one of our attorneys, I don't think here in the state, do that for their pet named Muffin Top, and they got a certificate and everything. Well, Muffin Top was an elephant, so now we have an elephant certified as emotional support. And I think what we've seen over the very recent past, we owe a big debt of gratitude to Dexter the Peacock, whose owner tried to board him in January on a Delta flight, and sent everybody into a tailspin. It made Delta come out and finally reevaluate and put some firm guidelines on their travel ban, because the airlines and the apartment industry, I think, are the two industries that we really need to get together on this, because they've seen an exponential increase in people flying, because they've figured out when you have an emotional support animal, you pay your $79 fee, you then can take little Fluffy everywhere you go, and oh, by the way, you don't have to pay any kind of airline fee or cargo fee or animal pet deposit or pet rent or anything like that, and that's where the real problem is. And so all these things about feed restrictions, weight restrictions, all of that goes in the trash can when it comes to emotional support animal. And some of the examples that I have, that I've had calls from, I had a call from a manager up in Denton, and they had some single-family houses, duplexes, and some smaller apartments. And of course, it's close to UNT, and they had 3 football players living in one house, a 3-bedroom house. And she received a note from their athletic trainer saying that all 3 of them had, emotional disability that required them to each have their own pit bull. And so she said, "What am I supposed to do with this?" And that was at the beginning of when all this happened, so, we didn't know what you could say yes to and what you could say no to. Another case, we have a board member who operates a number of properties here, and he said, "I had an emotional support Shetland pony, and this resident lived on the 2nd floor." And he said, "I hate to tell you, but I couldn't keep a resident on the 1st floor apartment because they put the clock all day and night." Also, when the support animal left, he had about $7,000 worth of subfloor damage he had to repair, and none of that is recoupable. So for us, it's a huge, huge issue. And we've been talking to our friends in Washington, D.C. on about a quarterly basis, saying, please, please, please have some sanity about this, because many people, many people are now taking advantage of it in airlines and apartments. And it's been a huge financial hit to our members as well. So we are petitioning them. I think with the last administration, things kind of went crazy, and we saw a lot of things come in that with not a lot of rules and regulations about it. And so we're hoping to see some guidelines for emotional support. And he's right, there's a few states We actually petitioned the state of Texas during the last legislative session, had a bill that was introduced. But I learned that our legislators haven't figured it out, and they didn't know that much about it at that time. Now there's been more news stories about it. And all we want, and what you'll find is those who are handicapped and truly disabled, they're just as angry about this as we are, because they're now been given a hard time when they go to a restaurant or Home Depot. They've got to prove all this stuff. They didn't have to before. And I know veterans groups are upset about it. So we're hoping that HUD will at some point come up with some reasonable guidelines again for these emotional support efforts. Thank you.
It's a hostile crowd. Well, you know, I think I would start with just distinguishing between the ADA and the Fair Housing Act. The ADA, by its nature, as was pointed out, applies to public accommodations. So we're talking about restaurants and you know, airlines and buses and maybe a few common areas of the multifamily property. Whereas the HUD made a conscious decision to depart from DOJ's tight interpretation of what a service animal is, because it recognizes that we're talking about a place that a person lives. And so, you know, when you're at home, that's when you're going to seek your refuge, seek your treatment if you need treatment, and those types of things. So, I mean, that's probably why you see the departure and HUD's up to this point unwillingness to limit support animals to just service dogs with a small carve out for miniature animals. That being said, the HUD guidance is pretty clear in some respects with respect to undue administrative and financial burdens. So, you know, one of the cases I had the distinct honor of investigating many years ago was a lady that kept a horse in her apartment, and, you know, full-grown horse. We're not, Mr. Ed, not my pretty pony. And so, I mean, unreasonable, probably, you know, on its face. I wouldn't intake branch chief at that time, or I probably wouldn't have let it through the door. But anyway, so we had to investigate it, and, you know, it did. I mean, the horse caused, you know, a substantial amount of damage, and that's, you know, just you know, a logical expectation. So, I mean, if a person comes to you and wants to keep a horse, you know, in the second floor unit or first floor unit, I mean, the answer, you know, to that is pretty easily no. But that doesn't mean they're not going to file. It just means, you know, it's hard to stop that from happening. But, you know, beyond that, I know Melissa wants to weigh in on, you know, whether or not you need to accommodate the guest of a tenant and some other matters. So I'm just going to pass the mic.
Well, request for reasonable accommodation makes up probably the lion's share of the complaints that we evaluate in the city attorney's office that make their way up to us from our FAT, from our Fair Housing Office. And so I will just share a little bit of our experiences and what we tell people when these issues come up. First of all, one thing that I know we've cleared this up with others before, and that is if damage is caused to a structure that's rented to someone with a emotional support or service dog, whatever, there's nothing in the Fair Housing Act or in our local fair housing law that prevents or that would protect someone from a claim for that damage. So just to be clear, Fair Housing Act does not immunize someone for being responsible for damages caused by a service or assistance animal. A lot of the cases that we review have to do with, I would say that HOAs get into more sort of trouble, it's more problematic. Most of the time, because they are being run, the boards are non-professional property, they're trying to manage properties and they're not really professional property managers. I think a big caveat that you could keep in mind is sort of the old axiom, justice delayed is justice denied. Well, that is also true with requests for reasonable accommodations. We often see, and I see this with HOAs commonly, is maybe I know my own HOA can't seem to get anything done within, they talk about it for the first time and before you know it, a year later, and they haven't even talked about it again, much less made a decision about it. A request that the response to it is unreasonably delayed is a request denied, and we will treat it as such. Because a person has the right to know if you're going to grant that accommodation or not. I would echo what Patrick said about just because someone asks for something that maybe sounds on its face ridiculous, or asks for something that is ridiculous, then it's not going to be reasonable. You're not going to have a problem with denying it. Lastly, I would say, be careful in judging someone's right to an accommodation by the quality or an opinion of the authenticity of the evidence that they provide to you. Be careful with that. I would never take issue with sort of evidence that some, online site looks kind of fly-by-night, or like, I know there's a lot of places out there that are really exploiting people's bona fide or not bona fide need for some sort of evidence. A lot of people don't understand the law enough to know that if they are disabled, and that term under the ADA and fair housing law is very broad, encompasses much more than people in a wheelchair that are visibly disabled. In fact, most of the disabilities that we deal with are not apparent. They are disabilities nonetheless. Most of these folks, under the law, don't have to provide anything except, really the law would say if they know and they can articulate their disability and they can articulate their need for the, say, assistance animal, and they can articulate the major life function that their disability affects, and they can articulate the nexus between what the assistance animal provides and that disability, that handicap. That's what the law requires. The thing is, there are many, many disabled people out there who either don't understand that could be on their own word, really, or just someone who is personally familiar with that information. They don't understand that they don't need, they're intimidated by their landlord's sort of request or anticipated request for documentation. And they may go to a site like that, looking for something they can present. And we've seen these cases. We've gotten these cases in complaints. We filed lawsuits on these cases because their landlord said, oh, Pshaw, I think that's a load of hockey, and that's just one of those online places and we're not going to accept it. Well, it was one of those online places, but it was a bona fide disability and a bona fide need for the assistance animal. And their denial of that request was a violation of the law. And I think that very tiny HOA wound up paying over $50,000 to settle that claim. And that was because they wouldn't give an accommodation to the weight limit policy on their pet policy. just a weight limit. So you can see how easy it is to really get in trouble with those things.
However, we are recommending to our members now, because this is so prolific in our industry and it's really been abused, we are recommending to our members that they do ask for some documentation, that they do push back a little. Again, if someone has a legitimate need, that's one thing. But a lot of people are doing this, I had one owner call, he said, I've never had emotional support animal request, and all of a sudden in the last 30 days I've had 6 on a small property. He said it's because the residents are getting together and going, hey, guess what we can do? Yeah. So it's interesting though, if you say, okay, I go to an online site and you're answering a couple of questions, I can get, high strung or nervous or something. To me, that is still not having some sort of a medical professional say, this is really going to help you. And I just happened to run across something today. There was an article in the Washington Post, and it said that a lot of people are confusing their preferences to have their animal by their side with actual medical needs. And it says they try to put it, the effectiveness of emotional support animals is poorly substantiated through studies, but widely embraced by the public. So this is what we're up against right now. Everybody, it's a cute little puppy. Or the problem is when we talk about breeds and all that, we're usually talking about dogs, but with fair housing, lack of guidelines, everything and anybody. So we've seen goats and pigs and turkeys, and we've seen pictures and videos of turkeys on planes. So any animal, a boa constrictor, if it wraps around your arm and makes you feel warm and cuddly, I guess, that can be considered a support animal. And there are no restrictions that the head judge might tell us wrong. So that's where it gets really dicey for a property manager.
I want to make a couple of comments if I could real fast. One, with the HOA situation and the lack of education, we had a request 2 weeks ago, I guess, from an HOA down in the San Antonio area who had a pending complaint. They had someone in their association that was about to make a complaint, and they asked our office to provide someone to come out and provide some education. Fortunately, we were able to have one of our Fair Housing Initiative group folk go out, because it would have kind of been a conflict for us in that situation. But they did go out, and they had a big meeting, because they do have monthly meetings, I believe, at these associations. So I was just going to suggest that that might be a way to educate the members of the association or some of the HOAs, is when you do have your monthly meetings, invite somebody from the local fair housing office to come out and just talk about fair housing in general before you have a problem. And I think if you did that 2 or 3 times a year, that would help to fill that gap in lack of education. The other point I wanted to make is that among the guidance that's out there, and it's been out there for quite some time, is the joint statement between HUD and the Department of Justice on reasonable accommodation. And it talks about documentation of the need for the accommodation and the nexus between the request and the person's disability to be provided by a reliable third party. And to me, that's where this whole thing about the internet and all that kind of comes in. Reasonable accommodation was meant to be to assist people with disabilities. And housing providers do have a right to know that the person has a disability within the definition of the law, that a request is made and that the request is necessary for them to use and enjoy the dwelling, and that there's a connection between the request and the accommodation that's being requested. So you have a right to ask for that documentation, if it's not readily apparent. And the interactive process of going back and forth to get that information, that's what we look for. We like to see that that process has taken place. And I think of a request for accommodation almost like a prescription. I'm going to the doctor tomorrow to get rid of this stuff in my nose. But they're going to prescribe something for me. And in 2 weeks, if it's not better, they say come back. And that's kind of how the emotional support animal situation should be. Before we take a case to court, we like to have a statement from that either medical professional, or it doesn't have to be a medical professional. It could be a caregiver, a reliable third party. But we want to know what's the difference between this person's condition when they have this emotional support animal and when they don't. Have you observed that? Is that in your notes? And it is sometimes. And that's the question I raised about the online ones. I'm wondering how are they monitoring the progress of their patient? And I think that's a reasonable question. So we are concerned about that at HUD. If we see anything that looks fraudulent, we turn it over to the Department of Justice. And we've had a lot of experience. In fact, my boss got an accommodation for that elephant she was talking about. Remember? Yeah, did that. Because we wanted to test it ourselves just to see how easy it was. I think he had to send $75 or something, and he could have gotten his certificate. But that is a real issue for us as well. And so we share that with you, and we'll continue to work to try to eliminate that, because we don't want that to prevent other people who really need the emotional support animals, from getting them. The last thing I'll say is that in terms of breed and size and all that, HUD's position is that that animal is an extension of that person. And they are responsible for it. They're responsible for maintaining the animal. They're responsible for controlling the animal. And just like, I like to put it this way, if a person bites somebody, would you evict them? Yeah. So if the dog bites somebody, you evict them too. If they display aggressive behavior on a repeated basis, and you document that, you have a way to evict them and the animal. So that's the way I think you have to kind of think about it, and then that may help some.
Those are great points. Let me kind of address things maybe in reverse order. With respect to rules and regulations, let's take a look at maybe a restriction that says no pit bulls. Okay, and I don't think anybody in here would dispute that if we look at the news out there, if we're going to look at what makes the news in terms of the animal world and attacks on people, it's usually, or it seems to be at least, a pit bull dog or some other type of dangerous or what we consider to be an aggressive breed dog. So when we have rules in a community, sometimes those rules, or most of the time those rules are written in anticipation of a problem, to be proactive to try and prevent an issue as opposed to being reactive. And so what this accommodation request basically does is it kind of says, well, we're going to take your proactive view of just the animal itself in general and make it a reactive thing and say basically, well, it's like any other animal, and if it bites somebody, then great, it's out. But even though it might have a propensity in the public's eye to actually be a more aggressive, more of a danger to people because it's there than it otherwise would be. So that's kind of just one comment on the rules. Then with respect to taking a look from an HOA standpoint or even a department standpoint, the rules basically we know, is the disability apparent or not? And of course, as we've indicated, in most instances when we're dealing with a request for an accommodation, the disability is not apparent. So then we've got to go to the next prong, is that the person making the request is the disability-related need for do they have a disability-related need for the assistance animal? And that's where we get into the unclarity of what my communities can ask for. When they come to me proactively and they say, we've got a request, I tell them, you have a very small window. If the disability is not apparent, you can ask only X. You cannot ask what the disability is. You can only ask related to, do they have a need? What verifiable information can they give you that this disability requires the need for this assistance animal? And that's when we get sometimes these, online things. And if it's just that and only that, and we've seen that person without the animal, and then they come in with the animal and they can't give us anything else, then I tell them, make your decision on that. Take your risk. If it's anything more, if it's the neighbor, if it's a nurse practitioner, if it's a doctor, and most folks, I'm telling you, most folks will give up something. They'll go to their doctor and say, yeah, you know what? And the doctor will write something out and say, you know what? This person needs this animal. And hey, that's great. And personally, from my standpoint, from a practitioner standpoint, advising folks, I would love to see some bright line that just simply says, what is the acceptable verification? And I know it could change. And I know Thurman, you even said it could be the person says, I need this animal. Or the friend says, this person is better off with this animal. But what pet owner isn't better off with their pets in front of them? And again, that gets to the subjective nature of this. Most people that own pets love their pets and wouldn't want to be without them. So they're better off with them. So I don't think that could be the standard. But there's got to be maybe a little bit more help for the industry that these managers for apartments, for homeowners associations, can look to and simply say, if they check these boxes, then there's just absolutely, you've got to agree to it. There's no fudge factor there. If they don't check all these boxes, then there's a window where the association can, at least on its face, reasonably make a denial. And then the homeowner or the tenant or the resident would have some type of ability to then respond with further information. That's kind of all I'm thinking. It shouldn't be a difficult process because the goal is to protect those with disabilities. The problem is those people with disabilities, their rights are almost being trampled on because there's a lot of abusers of the system. And that's the problem.
Just to make a couple of really small clarifications. We would be looking for not just that someone feels more comfortable with their dog. We're looking for a disability as that's defined under the law. So that's not just I feel better with my animal near me. And it's not just, oh, I sometimes get sinus headaches. It's a disability under the law. I was just making the point it's broader than people who have visible handicaps. And it's not just that they feel better with the animal, but to be able to articulate, or someone with knowledge be able to articulate the handicap isn't the disability, it's what's the handicap that it causes and the impact, the major life function it impacts. And then that the animal is necessary, why the animal is necessary, and that there's a nexus. So it really is pretty well laid out in the law, what it requires. And like I said, just because someone brings you a document that doesn't look genuine doesn't mean that the need isn't genuine. And we would just caution people to be careful about judging the disability by the authenticity of some paper that says, yes, that's an assistance animal. I also wanted to make another point that in one case, it was extremely well documented disability. In fact, the woman at one point gave up her entire medical file to the HOA's lawyer, who ostensibly practiced in real estate law. He represented HOAs, sort of unbelievably to us. We filed that case based entirely on, exclusively on, the lawyer's words in writing to the complainant. And it was one of the most egregious cases of discrimination we'd ever seen, because the lawyer wasn't particularly well educated about, or was ignoring, perhaps, what the law said about what was required, and based the entire denial on the fact that one of the voluminous documents that the complainant had given to the HOA and to the lawyer to the HOA, amongst all those documents was one of those online certificates. They based their whole decision on their sort of, harumph feeling at seeing that. And like I said, it turned into a lawsuit that they just couldn't defend.
For clarity, it wasn't me.
That's right. No one in this room.
I just want to
I would advise to allow the animal.
touch on a couple things real quick. I kind of, just in the way that the discussion has meandered, I feel like we've maybe constrained what is a disability a little bit. There's 3 ways you can trigger protection as a person with a disability, and the one that we keep touching on is a person that has a substantial limitation of major life activity. But you can also trigger those protections by being regarded as disabled, and also by having a history of disability, which would show up like in your paperwork. Most commonly, we see this like in persons that have like housing choice vouchers or living in public housing or something like that, and it's in their paperwork, or a LIHTC property, where the documentation tends to be pretty substantial, and we're talking about persons with low income, and the source of their income might be SSDI. The reason that I emphasize that is because when you consider that, and then what sounded like a recommendation for just a blanket policy that you document every request, the HUD DOJ guidance kind of gives you 3 tiers of inquiry, and the first one is if the person has an apparent disability and an apparent need for the accommodation, then documenting either one's not a good idea. The example I give is the easy one. The guy that comes in that's clearly blind or has a substantial vision impairment, and he has a seeing eye dog. You need to ask yourself, have an internal dialogue at this point if you think you need to document that. Because if he files with HUD, we're just going to look at the guidance and say, okay, why did you think that you needed to document that? Clearly not within the guidance that we've provided, and then make some decision as to whether or not to act. The second tier of inquiry is when the disability is apparent, but maybe you have a question about the need. These situations are a little bit more vexing, and so certainly, much like was suggested by council, you want to make a very narrow window of inquiry, and that narrow window of inquiry should be, does this person have a need for this accommodation, and will it ameliorate one or more symptoms of one or more of their disabilities? And then once you get an answer to that's clear. I mean, if you get some vague response, then obviously you do have the right to keep inquiring. But once you get something that says, yes, this person has a substantial limitation that would be ameliorated by having this accommodation in the following ways, that inquiry should stop at that point. And then the third tier is when, the person walks in and there's no indicator that they have a disability. And so not only do you not know whether or not they actually are going to be afforded the protections to those that have a disability, but also do they have any need for whatever it is that they're requesting. In that instance, your inquiry should be tailored to, confirm that they do have a substantial limitation of a major life activity, and then cease once you confirm that. And simultaneously, you would be trying to confirm that one or more symptoms of that disability have been ameliorated by the accommodation.
I just wanted to add a point too, if you don't mind, to address at least something that Mr. Glenn has brought up about, particularly when you're dealing with aggressive breeds, and what we have shared with different housing providers, whether HOAs or multifamily apartment complexes. If that disabled person has a dog that's perceived or identified as aggressive, be it a pit bull or whatever, if the dog has shown, or that animal has shown a propensity to be dangerous or aggressive, that housing provider has a right to say, I'm sorry, I'm going to deny that accommodation request. However, they can show themselves as acting reasonably with that disabled person by saying, look, I can't accept this dog. It poses a threat to the community and my staff. However, you have the right, if you can, or if you're willing to do so, to get a dog that can behave itself on property. And if they come to our office and demonstrate that they tried to work with that disabled person, they've been reasonable in that interaction. And
we won't make a decision, but I think there would be some difficulty in finding that they have shown any propensity to try to discriminate or deny that person based upon their disability. Act against that specific animal. Yeah, the animal is a problem. However, yes, you have a right to an accommodation. It just can't be that animal. Now, on the point about the horses or exotic animals that can pose a problem, if it's a health and safety risk, that's another issue that can be explored to say, okay, I'm not sure that that's going to work, and you may have grounds to deny that person the right to have that specific animal as an accommodation. So those are the points I wanted to sort of add.
And if I can comment further, Marcel, we've seen cases like that where we've advised people that you're going to evaluate those, say, the dangerous dog on an individualized basis. It's called a direct threat defense to reasonable accommodation request. So, in other words, whether you could have a disability, for example, and a person who says, I need an accommodation for my disability, but the disability itself has shown to have made that person a threat to other people or property where they live. So maybe they're saying, well, don't hold it against me that I, broke my neighbor's door down with an axe when I was having a psychotic break because I didn't take my meds.
Another one too, where they're out and the person is taking their clothes off.
Right, that was
a recent case. Naked. Right on the property.
Right. So if the person has a history, and same with the dog, if the person or that dog has a history that would lead you to believe you can predict their future behavior by their past behavior, that they would cause a direct threat to people or property, then you can deny that request. It's not reasonable to grant that request. The request itself is not reasonable. Versus a person who has a mental illness, but you don't want that person living on your property because of your stereotypical ideas about what people with that mental illness they might pose. The direct threat can't be based on stereotypes, generalized beliefs. That's discrimination. That is discriminatory. So look at the individual, and we would say, same thing with the animal, look at the individual animal. We've had pit bulls in our complex, and I tell you that it completely freaked me out when I saw it, because I have a little tiny poodle that I thought was going to be eaten by that dog someday. Dog turned out to be just like sweet as pie. Great dog. So that's a great dog. Others maybe not so. Individualize the inquiry.
I have a thought that I would like to see one change made that would make a lot of difference, I think, to the perception from the owners and managers. Would be that you'd be allowed to require a deposit, and you'd be allowed to require a pet fee or pet rent for an animal that is an emotional support animal, just like a regular pet, because I think the biggest concern most of you have is that a high percentage of animals cause damages to your property. And lack of a security deposit really means you're not going to collect, even though Ms. Miles said you do have the right to sue someone for damages. If you don't have the money in hand, for many of your residents, you would never collect if you sued and got a judgment. And if you just were able to have a deposit on hand, that would help offset some of your losses related to the emotional support animals. And I think it also would help eliminate or minimize the number of people requesting emotional support animals that are not really seeking it for an emotional support need, but they're seeking it because they want to avoid paying a deposit, they want to avoid paying pet rent, etc. If that one simple change were to be made, I think that would resolve a huge part of the controversy that we're involved here. But absent that, I really think we have mixed messages. You want to throw up your hands. That both Ms. Miles and I heard a DOJ official say this in Austin last week, was that the law says that if the person is disabled they're entitled to an accommodation. It doesn't matter what actually evidence is that you're given at the time they ask for it. They might be able to show at a trial that they did have a disability and that you denied the accommodation for the disability. And that is a concern that I have from your perspective, is that if you make the wrong decision, even though they did give you some bogus certification that this was a support animal for them, that you still could be held liable in the end for a denial under those circumstances. And so that's why we need some changes to the policies that HUD is implementing, not the policies of the owners and the managers.
Thank you. What we want to do is certainly give the audience here an opportunity to pose any questions you may have, so if we can take a couple of questions if you have any. Do I have anyone out here? Any? Yes, ma'am. Just a moment. I think it's going to bring you up. You have the mic.
I just have a question in regards to like discrimination, and you guys were talking a lot about animals and disabilities and things like that, but I'm curious about where discrimination falls as far as vouchers come in. A voucher simply indicates that an individual is capable of paying a portion of the rent, but it may not necessarily all be coming from their own income. So where would you find discrimination, or where would you define discrimination and draw a line where apartments are unwilling or they're not willing to accept vouchers? I mean, regardless of the person's, like, they don't have background, you know, there's nothing wrong with their backgrounds, there's no evictions or anything like that. Like, would that be a discrimination as far as like them not being willing to accept the voucher?
Well, from her standpoint, that would be any city that has an ordinance or a state statute dealing with source of income as being a protected basis. But for the Fair Housing Act, it is not a protected basis. So we don't, any landlord who chooses not to accept the voucher is not a violation of the Fair Housing Act. But if the city of Dallas,
the city of Dallas does have what we call source of income discrimination ordinance. It does not encompass, it's not as broad as it might have been had the state of Texas not passed a law that said cities can't have source of income ordinances that would require landlords to accept housing vouchers, for example. So the only provision in the local ordinance that would regard a refusal to take a housing voucher as discriminatory is if the landlord was accepted a certain amount or certain percentage of government funding for the housing project development. Otherwise, it really is limited because of state law.
Yeah, so what she's saying is that if an apartment complex has accepted some type of government money from the city or some other entity, they cannot deny a person housing because they have a Section 8 voucher.
I'm going to put my former career hat on. I used to work on the nonprofit side, and probably about 20 years ago, there was a practice that we challenged in the Austin area about requiring 3 times the rent. And we argued that it had a disparate impact, and successfully argued that it had a disparate impact on students and I believe also persons with disabilities. And so, you know, we're back to the ICP type of disparate impact, kind of come full circle from where we started this whole panel thing, talking about disparate impact, just in a different vein. So even though vouchers per se are not a protected group at this time under the federal statute or at the state level, you still have an avenue if you can put the data together in the right way to frame it as a disparate impact claim.
Also, too, I want to add, as it relates to specific instances where a voucher may be required to be accepted, or at least within the city of Dallas, if there is a carve-out for veterans with special veterans vouchers, they cannot be denied as well. But again, that's a special carve-out for that specific group of individuals. Any other questions? Yes, sir.
Can they deny housing discrimination in terms of age?
Unfortunately, age is not a protected class, neither under the Federal Fair Housing Act nor under the city's Fair Housing Ordinance. So at this point in time, and maybe in some other city in the country, they may recognize age as a protected class. But here in the city of Dallas, there's no provisions under the law to protect someone based upon their age.
Is there any way that the city can do something about it? Can you change the, make age a protected class?
Let me comment. If the housing is federally funded, then there is protection under the Age Discrimination Act of 1975, but it has to be housing development that's federally funded. And you can file a complaint with our office, and there are some elderly developments out there that probably would qualify for that.
Yeah, I was gonna, can you hear me? I was just gonna suggest that if you have a property that you think is discriminating against you based on age, to contact HUD, because one of the things that we can do is we can research the property through a few different internal mechanisms to see whether or not there are any HUD funds in the property. Because when we say HUD funded, most people have a picture of just public housing, but HUD, through its Office of Multifamily Housing and also through its Office of Community Programs and Development, does provide funding to multifamily properties in various amounts, but just the smallest amount would trigger protection under the Age Discrimination Act. And so we would be able to look into that and tell you whether or not you would have standing under that statute.
Thanks for the clarification. Well, how was this? Did y'all enjoy this evening? As you can see, these are complex issues that certainly come not only before the federal government, but certainly before with our office as well. And I hope you were able to get some information that you can take with you, especially you housing providers, back to your office. I'm sort of wondering, I have questions in my mind. How many of you would like to see something like this take place in the near future? Not necessarily dealing with this, but with other issues and questions that you have related to fair housing. Give me a show of hands. Okay, so as you can see, Ms. Davis, we have an interested audience here, and certainly some things we may want to go back and consider. At this time, we certainly want to recognize and thank our guests who volunteered to sit on this panel and share their expertise with you. So at this time, we're going to present them with certificates. First, I'd like to acknowledge and recognize Mr. Thurman Miles.
Thurman, I saw Thurman in Austin last week, and I know as a regional administrator and director, he has gone all around this southwestern region to different fair housing events. So I asked him if he could count how many he's already been to, but the thing that amazes me about Thurman is that every time that he speaks or comes to an event, he brings the same energy and enthusiasm, just like it's the first time. So we appreciate it every time we call on him, he comes. And so thank you very much, Thurman.
And certainly express a special thank you to Ms. Melissa Miles. I want to thank Mr. Patrick Vance. I guess I shouldn't give you the left hand. We get it all confused here. This is my guy here. I'm telling you, for real. I can call on him anytime. He's always very good with, insightful information to help us to be able to do the jobs we do. So thank you.
And we really do call it the bat line.
He does. All right, next I want to thank Mr. Jerry Carlton. Thank you. Mr. Carlton has always been helpful too. Now, a lot of times you're on different sides of the issue, and as you can see, he does an excellent job of representing his clients. But one thing I can say about him, he is always amenable and open to looking to see if there are options available for us to try to reach some type of resolution pertaining to a specific complaint or issue that's before us. So thank you again. And last but not least, Mr. Robert Blaine.
I would like to say this about Mr. Glenn. He conducted a workshop for us on homeowners associations and how they work. And if any of you have ever lived in a place where you have homeowners associations, you know that sometimes they can have very esoteric rules that they enforce, sometimes to the extreme extent. And so we've seen some very unusual situations in homeowners associations. And so he did a class for us where he kind of helped us to understand how they work. So we want to thank you for that as well.
Thank you for the opportunity. Before we conclude our session today, we want to acknowledge one other person who's been a valuable resource, not only in helping to put this program together, but demonstrated leadership, commitment, dedication to all that we do. I mean, our office would not be able to function without this person. So at this time, we would like for you to give a round of applause to acknowledge the leadership and work of Mrs. Beverly Davis.
That support us in everything we do, and a special shout out. I mentioned Shan Williams and Shanice is out there with her. I don't see Justice, but we work very closely with our community development office on doing a lot of meetings and events, and we talk to them daily and support each other. So I want you all to stand in because we could not do our job without you. And we want to know education is an important part of what we do. So if you need training, if you need us to come out to your location to be able to provide any type of training or guidance, we're willing to do that. We want to stay in touch with the community and to also make sure that we're there and providing you with the information that you need. So feel free to call on us if you're having an event, whether it's at your church or some other type of community event, we'll be more than happy to come and participate. So we thank you. This has been a very good day. We started out in the morning with some excellent speakers. We had our panel this morning on affordable housing, which was very informative. And I thought we had an excellent lunch and a nice little break there up on the first level. And so now we're concluding today with our panel who did an excellent job. So this day could not have been a success without you. I applaud all of you who came and stayed the whole day. I know that there are other things you could have been doing. So thank you very much for sharing the day with us. And be safe going home. Thanks.
This is William, hopefully your favorite videographer from Two Hats Publishing. I hope you enjoyed this video. If you like it, please leave comments below or like, follow, or subscribe to us and get notices of all our videos. We love it, even when you call.